Jefferson County Court at Law number 2 is in session. The court is in session in two cases, cause numbers 23 CCCR 1763 and cause number 26 CCCR 2275. Both cases are styled the state of Texas versus Guillermo Castillo III. And Mr. Castillo, is that your full name?
Yes, sir.
Mr. Castillo, would you please raise your right hand? Do you swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Castillo, you may put your hand down. How are you doing?
I'm doing good, Your
I'm
Honor.
that's good. Mr. Castillo, you're represented by your attorney Gary Gilthorpe. And Mr. Gilthorpe, how are you doing?
Good, Judge, thank you.
And Mr. Gilthorpe, do you waive a record in Mr. Castillo's cases?
Yes, Your Honor.
State is represented in this case by Attorney Farrah Nixon. And Attorney Nixon, how are you doing?
I'm fine, Your Honor. How are you today?
I'm doing fine, thanks for asking. And Mr. Castillo, I have before me on my computer a document that is titled information. This information is in cause number 26 CCCR 2275. And in this information that has been filed by the Jefferson County District Attorney's Office, it alleges that you, Guillermo Castillo III, on or about April 23rd of 2023, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of obstructing highway passageway. And this information further alleges that from August 29th through August 29th of 2023 until August 11th of 2026, and information arising from the same set of facts was pending in a court of competent jurisdiction, to wit, cause number 23 CCCR 1763 in County Court at Law number 2 of Jefferson County, Texas, styled the state of Texas versus Guillermo Castillo III. Is that true?
Yes.
Now, to the Class B misdemeanor offense of obstructing highway passageway, how do you plead? Guilty, not guilty, no contest?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you are guilty?
Yes.
And Mr. Castillo, I also have before me on my computer a document that is titled Misdemeanor Plea Admonishment, also labeled as State's Exhibit number 1. Do you recognize this document?
Yes, Your Honor.
On page 2 of this same document, there's a set of initials on a line next to a box that says check guilty. Did you place your initials on the document?
Yes, Your Honor.
On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, Your Honor.
And on the next document that's titled charcoal certification of defendant's right of appeal, do you recognize this document?
Yes, Your Honor.
And is this your signature on the line that's titled defendant?
It is.
At the top of this document, there are 2 boxes checked. The first box checked states that there is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
I also have the discovery certification.
Sorry, Your Honor.
I also have a document that on paper that is titled discovery certification. And do you recognize this document?
Yes.
And is this your signature on the line that's titled
Yes.
defendant? Now, Mr. Castillo, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes, he
And
did.
did you understand everything that your attorney went over?
Yes, I
And
did.
is everything in these documents true and correct to the best of your knowledge?
Yes, Your Honor.
Mr. Castillo, are you a citizen of the United States?
Yes, I am.
State offer State's Exhibit 1.
Any objections?
No, Your Honor.
No objections. State's exhibit number 1 will be admitted. Mr. Gilthorpe, you've advised in counsel. Mr. Castillo, is there any evidence that he's currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Castillo, your attorney, Mr. Gilthorpe, has advised in counsel. Are you satisfied with his services?
Yes, I am.
Okay, Mr. Castillo, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, you do, Your
And what
Honor.
is the agreement?
The essential term is $1,000 fine and dismissal of case 23 CCCR 1763.
Okay. What's the court cost?
$330.
3. Okay. Mr. Castillo, state is offering that you, sir, pay $1,000 fine plus court costs of $330, which comes to a total of $1,330. And are you able to pay that today?
Yes,
Okay. Now, Mr. Castillo, do you understand the state's offer?
yes,
And do you accept the state's offer?
yes, I do.
Mr. Castillo, I will follow the plea bargain agreement that you have entered into with the state. Mr. Castillo, you're gonna stand at the end of that table, follow the directions of the bailiff. Once you finish following the directions of the bailiff, you can go downstairs, make a payment to the county clerk's office, and then you can bring your receipt back upstairs and give it to our our court coordinator.
All right, thank you. Your
Right.
Honor.
You're welcome. You have a blessed day.
Thank you.
And Mr. Gilthorpe, you have a blessed day as well.
Thank you, Jim. You can,
Did.
Just one.
And you'll be able to get a copy of the dismissal. Hey, you're gonna get a copy of the dismissal tonight.
Oh, and endanger your child. Whoa, with intent to return that we established with and without and an assault violation.
Okay,
I'm giving a paper. Oh, what? Come on.
he has to go downstairs to make the payment.
Yeah,
On the bottom of the.
yeah, Jared. Jared.
Come on.
Okay, good morning, ladies and gentlemen. I'd like to welcome you to County Court 11-2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court 11-2. You have been asked to come to court today for what is called an arraignment. And what the arraignment is just an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning the case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Your criminal cases are divided into felonies and misdemeanors. Now, your felony cases are commonly referred to as your more serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offense. It does not mean that they're not serious, it just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top, work our way on down to the bottom. We have the capital murder, first degree felony, second degree felony, third degree felony, and the state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a third degree felony, a first degree felony, the range of punishment is minimum 5 years to a maximum of 99 years or life in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of the highest felony, which is a capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about those type of punishments because, as I mentioned to you, your case is a misdemeanor case. And misdemeanors are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the class A misdemeanor, the class B misdemeanor, and the class C misdemeanor. He needs to get a copy of his dismissal.
Oh, you can dismiss.
Okay, and, the class C misdemeanor are cases that, class C misdemeanors are cases that start in the city court or the JP court. They come to this court when a person, is convicted in the city court or the JP court, and then they appeal the case. When they appeal their case, they get a whole new trial. And the punishment range does not change. Now, the punishment range for a class C misdemeanor is a fine only. You cannot be given jail time, you only can be given a fine. And the fine cannot be above $500, okay? Class C misdemeanor, I'll just give you an example. It could be like not having your seatbelt on, or speeding ticket, or having expired stick. Those are class C misdemeanors, okay. Now, the next highest misdemeanor is a class B misdemeanor. With the class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days in the county jail, and a fine that does not exceed $2,000. Now, the highest misdemeanor is a class A misdemeanor. And in class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is a year in the county jail. Or you could be given a fine that does not exceed $4,000, or you could be given both such fine and confinement. Okay. Now, you may be eligible for probation. There are 2 types of probation. One type of probation is called unadjudicated probation, and the other type of probation is called adjudicated probation. So we have unadjudicated probation and adjudicated probation. With the unadjudicated probation, if you get that, it does not result in a conviction on your record. And if you successfully complete the probationary period, the case will be dismissed, and you may qualify for what is called a non-disclosure. And what a non-disclosure is, your record will be sealed to the general public. So the general public cannot have access to your record. Now, the operative word that I used was general public. Now, the general public is most of the public. Now, the Texas Code of Criminal Procedure, lists some agencies, governmental agencies that can have access to it. For example, like the police department. But most of the public is general public. So for example, let's say you're applying for a job at ExxonMobil and you have a non-disclosure, right? ExxonMobil, they will do a criminal background check on you. You have a non-disclosure, guess what? That record is sealed. They will not know that you were on deferred adjudicated probation for this case. Okay? Now, the next type of probation is called adjudicated probation. Now, with adjudicated probation, which is a regular probation, it does result in a conviction on your record. However, there is something that is called judicial clemency. Judicial clemency means that the judge can set your conviction aside. You will no longer have a conviction. Now, in order for that to happen, three things has to occur. One, you have to successfully complete the probation. Two, there cannot be any more time left on your probation. And three, the probation department has to successfully discharge you off of probation. If those three things happen, then the court has the discretion to set your conviction aside and you no longer have a conviction on your record. So if they go and look for your record, it's not a conviction. All right. Now, if you get a subsequent conviction, which means that if you get another conviction later on for something else, then the case that you receive judicial clemency on can be resurrected. It can be brought back up. It can be revived. And it can be used against you. And if you try to get a license with Child Protective Services, they can either deny giving you that license, or if you have a license, they can revoke or suspend the license. Okay. Now, everyone here, for a case, you should have a clipboard. You have to, okay. Okay. I'm going to go over the paperwork on that clipboard. On that clipboard, you have basically three documents. One document, the first document should be the judge's explanation of rights to defendants without an attorney. That's the one-page document. And I will constantly refer back and forth to that document as I go along. The next document should be the Jefferson County Affidavit of Indigence. It is a 3-page document. Okay? It's a 3-page document. And then the other document is a 1-page document. It's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Okay, do you have all of those documents? Okay, all right. Now, let's go back to the first document. Judge's explanation of rights to defendants without attorney. And it states that as a defendant in a criminal case, you have 3 options, and they list the 3 options. Your 3 options is regarding your right to have an attorney. Number 1, you may hire an attorney. Number 2, you may request that an attorney be appointed to represent you. And number 3, you may represent yourself. Now, number 1 states that, well, the first sentence under number 3 states that if you want an attorney and you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given another court date from today to give you time to hire your attorney. All right. Now that's for individuals who like to hire an attorney. Now, the second 1-sentence paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed by the court to represent you. But you must first sign and a written questionnaire. Now, the written questionnaire that they're referring to is the 3-page document that I had you look for earlier that's titled Jefferson County Affidavit of Injury. All right? Now, you can turn to that right now, and the document looks like this. It looks like this. If you want to apply for court-appointed attorney. Now, this is only for individuals who will be applying for a court-appointed attorney. If you're applying for a court-appointed attorney, listen up. You need to fill out the first page, and we're gonna give you time to do that later on, but you need to fill out the first page, and then you go to the second page, where it's at the top, it says defendant's oath. You'll fill out that top portion. And then you'll fill out the middle portion that's titled unsworn declaration by defendant, and then you'll stop, okay? That's only for individuals who will be applying for a court-appointed attorney. All right, now, going back to the first document, judge's explanation of rights to defendants without attorney. Now, I told you that you have 3 options. You can either hire your own attorney, you can apply for a court-appointed attorney, or you can represent yourself. Now, that's what this third one-sentence paragraph is talking about. It's for individuals who will be waiving their right to an attorney. Waiving your right to an attorney means that you're giving up your right to an attorney and you'll be representing yourself. Okay. Once you waive your right to have an attorney, you represent yourself, you are your own lawyer. Okay? So just like the lawyer can talk to the prosecutors or assistant criminal district attorneys in court about your case, you'll be able to talk to them about your case as well. Now, this third one-sentence paragraph states that you may not talk to the prosecutors unless you first sign a waiver of your right to be represented by an attorney. The waiver of your right is that other document that I showed you, I referred you to on the clipboard is titled Waiver of Counsel for Purposes of Entering a Guilty Plea. Now, this document will only be filled out by those individuals who will be representing themselves. So, if you are not representing yourself, you don't have to worry about this document. This is only for people who will be representing themselves. And let me back up. And if we go back to the fact that if you want to apply for a court-appointed attorney, then you have to sign this document. If you are not applying for a court-appointed attorney, you don't have to sign this document. Okay? And so this paragraph in block form states, and this is for individuals who will be representing themselves. It says that be aware that the dangers and disadvantages of self-representation, waive your right to an attorney representing yourself, may result in the worst outcome for you and your case, including the loss of significant rights and opportunities related to military service, possession of firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you're representing yourself, this last one-sentence paragraph states that you may change your mind at any time and request that an attorney be appointed to represent you. So what that looks like is this. Let's say you're representing yourself. And let's say you would like to talk to the prosecutors to see if the prosecutors will give you maybe just a fine in this case. And let's say you talk to the prosecutors. And they say, well, we're not gonna offer you a fine, we're just gonna offer you probation. And you may say, well, I don't want probation. Then you say, well, Judge, I would like to apply for a court-appointed attorney. You can do that. All right. Now, at the bottom of this document, this one page, this first document, there are three lines to the left. Everybody in here is gonna place your initials on one of these lines, whichever line apply to you. So for example, if you would like to hire your own attorney, then you will place your name, excuse me, your initials on the line, on the first line to the left. And then you'll sign the bottom of this document where it says defendant, and you will date it today's date, August 11, 2026, and then you'll stop, and this is the only form that you would have to sign. That's it. All right. Now, if you have already hired an attorney to represent you, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. Okay? And then you sign your name at the bottom, date it, and stop. And this is the only form that you have to sign. If you would like to apply for a court-appointed attorney, then you'll place your initials on the third line to the left. Okay? The third line to the left, you sign this at the bottom, where it says defendant, you date it today's date, and then you will fill out the document that is titled Jefferson County Affidavit of Indigence. You would have to fill out the entire first page. And then on the second page, you fill out the top portion that's titled Defendant's Oath. And then you fill out the middle portion that's titled Unsworn Declaration by Defendant, and then you will stop. Okay. Now, going back to the first form. If you have already been appointed a court-appointed attorney, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right of the fourth line. Okay? And then this is the only form you have to fill out, and then you'll stop once you sign your name and date today's date. Now, if you would like to represent yourself, that is, waive your right to an attorney, represent yourself, then you would have to place your initials on the fifth line to the left, sign where it says defendant, and then you would date it today's date, and then you'll fill out the form that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You have to read this paragraph, sign on where it says defendant, and date it today's date, and then you stop. Do we have any questions? Yes.
And so whenever you tell us what we've been charged with, can I risk it and give me what I'm pleading for? And can I reset my case and give me my own
No, you,
structure?
yeah, that's the first one. Yeah, that's what it says here. Right here, it says that if you would like to hire your own attorney, if you want an attorney, you have enough money to hire your own attorney, your case will be reset to give you time to hire your attorney.
No.
Is that your question?
Yes, sir.
Okay. Anybody else? Okay. Okay, now, I'm gonna give you time to fill out that paperwork. I need to go over a few more rights that you have. Another right that you have is, you have a right to, well, first off, before we do that, I need to tell you the three types of pleas that you can enter into. First, you can enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you have been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you have been charged with. Or you can enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you will not be fighting or you will not be contesting the charges. Okay. Now, if you, for example, if you enter a plea of not guilty, you're telling the court that, you want to have a trial. Now, there are two types of trials you can have. You can have a jury trial or you can have a bench trial. Now, that area over there, it's called the jury box. They have 12 chairs, but in county court, 6 people are selected to serve as a jury. In district court, 12 people are served, selected to serve. but you have 6 people that will be selected. They will listen to the evidence of the state, listen to the evidence of the defense, and listen to the arguments of the state and the arguments of the defense. And then they will go back in behind those doors. There's a room back there called the jury room. They will deliberate. And then once they finish deliberating, they can either find you not guilty or guilty. Now you have a right to waive or which means to give up your right to have a jury trial. You can waive your right to a jury trial, which means you can give up your right to have a jury trial. If you waive or give up your right to have a jury trial when you desire to have a trial, then you can have what is called a bench trial. And what a bench trial is a trial by judge. And the reason why they call it a bench trial is because the judge sits on the bench. So they call it a bench trial. Now, the judge will be the judge and the jury in the case. The judge will listen to the evidence of the state, the evidence of the defense, listen to the arguments of the state, listen to the arguments of the defense, and that the judge will apply the facts to the law and decide to find you either not guilty or guilty. Now, if you enter a plea of either guilty or no contest, you're telling the court that you would like to enter into a plea bargain with the state. Now, there are 2 types of plea bargain. One type is called an agreed plea bargain. The other type is called unagreed plea bargain. So I'll explain the 2. With an agreed plea bargain, as I mentioned to you earlier, let's say you wanted a fine. And let's say the state agreed to give you a fine. Okay? Then that's an agreement. With that agreed plea bargain, it goes before the judge, and the judge can do 1 or 2 things. The judge can either accept or reject your plea bargain agreement. So if the judge rejects your plea bargain agreement, meaning that the judge says, I'm not going to go along with it, you have a right to withdraw or take back your plea. So for example, what does that look like? It looks like this. Okay, you're in the state of talk, y'all have a plea bargain agreement. You say fine, it goes before the judge. The judge say, well, I'm going to withdraw, I'm going to reject that agreement. And you say, well, judge, since you are rejecting that agreement, I take my plea back, which means I'm not pleading guilty and I'm not pleading no contest. All right? You have a right to do that. Now, if the judge does follow the plea bargain agreement, and let's say within 30 days, you decide that, you would like to file an appeal or a motion for new trial. Then if that's the case, you have to get permission from the judge that follows the plea bargain agreement. Now, if the judge gives you permission, then your case is going to leave this court. It's going to go right upstairs to the 9th Court of Appeals. And there are 4 judges or justices that sit up there. They will listen. Now, first of all, once the case is there, they can do 1 of 2 things. They can grant or deny your appeal. If they grant your appeal, they can simply find you not guilty, case over. Or if they deny your appeal, then guess what? You can appeal your case to a higher court than the 9th Court of Appeals. And you can appeal your case to the highest criminal court in the state of Texas. And the highest criminal court in the state of Texas is located in Austin, Texas. And it is called the Texas Court of Criminal Appeals. And there are justices there. They will, once they get your case, they can do 1 or 2 things. Well, first of all, you have to file what is called a pro se petition for review. I'll explain it to you. Pro se means you by yourself. You don't have a lawyer, pro se. And you petitioning the Texas Court of Criminal Appeals to review your case. Why? To see whether or not the 9th Court of Appeals should have granted your appeal, or whether or not this court committed an error. Okay. They can do 1 or 2 things. They can grant or deny your petition. If they grant your petition, guess what? They can simply find you not guilty, case over. Or they can send that case back to the 9th Court of Appeals with orders, or they can send it back down to this court with orders. Now, if they deny your appeal, then at that point, your petition, then at that point, your conviction will stand. Okay. Now, I mentioned to you there are two types of plea bargain. One was an agreed plea bargain, and the other is an unagreed plea bargain. Let me explain what an unagreed plea bargain is. An unagreed plea bargain looks like this. You and the state have talked. You want a fine. They want to give you probation or something. You don't want that, but you still want to plead. You don't want to try. So you have a right to go to the judge for the judge to decide what your punishment will be. That's called an unagreed plea bargain. You couldn't make an agreement with them, so it's unagreed. You want the judge to decide. And so the judge is going to give you a punishment anywhere within the punishment range of the case. Okay. All right. Now, the next thing we need to talk about is if you're going to trial, you have a right to have witnesses. Witnesses sit in a chair that's in front of that microphone. And we call that the witness stand. Now, what witnesses can do, they can either testify for you or against you. Now you have a right to call witnesses to testify. They can testify for you or against you. You also have a right to waive your right to call witnesses. Waiving your right to call witnesses means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses in the case that they have filed against you. Now, you also have what is called a Fifth Amendment right against self-incrimination. I'll explain that to you. The Fifth Amendment of the United States Constitution gives us the right to remain silent. Okay? The state, the government, the district attorney's office cannot force you to take the witness stand and testify against yourself if you exercise or invoke your Fifth Amendment right against self-incrimination. And so what that looks like, it looks like what they do on television. We see Law and Order, we see a television lawyer go up to the witness stand and ask the witness some questions, and the witness say, I take the fifth. That means that I'm not saying that I'm exercising my Fifth Amendment right to the United States Constitution. And you know what? To me, it makes sense to have that right. Why? Because the state of Texas, or the government, has the burden of proving that you are guilty beyond a reasonable doubt. You don't have to prove yourself guilty. All right? That's their job. Okay. Now, the other right that I'm going to talk about is your right to have discovery. And what discovery is, you have a right to see the evidence. The state has a file, it has evidence that they will be using against you in the case. You have a right to have access to that evidence. You have a right to see witness statements, your statements, police reports, lab reports, video recordings, listen to audio recordings, see photos, documents, and any type of instruments that they have, guns, or whatever instruments that they have. You have a right to have access to that. Now, you also have a right to waive or give up your right to have discovery. And what that means is you will not be having access to the evidence that the state has against you. All right. Now, everyone that's here today, you have been charged with offense, you've been arrested, placed in a county jail, you bonded out of jail, you get out of jail on a cash bond, which means you paid the full amount of the bond to get out of jail, or you're out of jail on a surety bond, which means that you pay a bondsman a percentage of the bond to get out of jail, or you may be out of jail on a personal recognizance bond or a PR bond, which means that you did not have to pay any money to get out of jail. You were just released under your own personal recognizance with a promise to appear here today. I've said that to say this. Every day that you spent in jail can be used as credit toward your punishment. The operative word is every day. And I'll explain that to you. Let's say you were booked into jail at 11:59 PM on last night. And let's say you booked out of jail at 12:01 AM this morning, 2 minutes later. Guess what? You get credit for 2 days. You was in jail 2 minutes, but you get credit for 2 days. Why? Because at 11:59, that was Monday. 12:01 was Tuesday. So that's 2 different days. So that's why you get credit for 2 days. You have to be there 24 hours. It's just a different days, Monday, Tuesday, whatever. But anyway, I'm saying that to say this, not every day that you spent in jail can be used as credit towards your offense. Let's say you spent 5 days in jail, and let's say the state is offering you 5 days in jail. Guess what? You don't have to spend no more time in jail. Why? Because you already spent 5 days in jail. Therefore, you'll be given credit for the time that you've already served. Now, if the state is offering 7 days in jail and you spent 5 days in jail, that means that you would not have to spend 7 days there, you don't have to spend 2 days in jail. Why? Because you have 5. We subtract 5 from the 7, that leaves 2. Now, every day that you spent in jail also can be used as credit toward your fine and court costs. So every day that you spent in jail, you are credited $100 per day. So if you spend 5 days in jail, you have $500 that can be credited toward your fine and court costs. So if the state is offering you fine and court costs of $500, guess what? You don't have to pay anything. Why? Because the time that you spent in jail has already paid it off. Therefore, it will be what we call taxed and retired. Now, if they're offering fine and court costs of $700 and you spent 5 days in jail, which is $500, that means you would have to pay $200. Why? Because we'll subtract 500 from the 700, that leaves 200. And so you'd have to pay that on the day that the case is disposed of. If you cannot pay, no problem. Why? Because we can put you on what is called a payment plan, which means you can pay it off in small monthly installments until it's paid off. Now, if you cannot pay off the small monthly installments, no problem. Because we can convert your fine and court costs to community service, which means that for every 1 hour of community service that you perform in a nonprofit organization in Jefferson, in our area, $12.50 will be credited toward the payment of your fine and court costs. So to further explain it, if you work 8 hours of community service one day, that's $100. That's credited toward your fine and court costs. So in our scenario, you need to pay off $200. You work 2 8-hour days, that's $200 that's paid off, and then you finish with paying off your fine and court costs. Okay. Now, Jefferson County District Attorney's Office has a program for first-time offenders. If this is your first time having cases filed against you, 1 or more cases filed against you, then they have a program whereby they will dismiss your case. You get it wiped off your record like it never happened. The program is called the Pretrial Diversion Program. And with that program, in order to qualify, it has to be your first time having 1 or more cases filed against you. And then the second thing, it cannot be for an offense involving unlawful carrying a weapon or resisting arrest. And then the third requirement, you have to have a lawyer to help you with the applications process. Now, the lawyer could be court appointed. It doesn't have to be a hired lawyer. Okay? So if you qualify, your case is dismissed, and you can get it expunged from your record, with me, erased, deleted, or wiped off from your record. An example that I always like to use is say, let's say when you got charged, your case, your record looked like this. Okay? That's how you can see all your stuff, or your record look like this. And once you get it expunged, guess what? It looks like this. Okay? There's nothing there. That's what an expunction is. Okay. Now, if you're a veteran of any branch of the military, if you're a veteran of any one of the branches of the United States military, the district attorney's office has another program for veterans only. It's called Veterans Court. And with the Veterans Court, once you get into the program, you complete the program, your case is dismissed, you can also get that expungement. Okay? Just only way to get, there's no requirement about, in terms of the type of offense. The only requirement is that you be a veteran. All right. Now, this court, County Court at Law number 2, has a program that God led me to start within the first 100 days of taking office in March of 2017. And that program is called the CSI program. CSI stands for Community Safety Initiative. And with that program, the program is designed to address the issue of what we call recidivism. Recidivism is where people commit crimes over and over and over. And so the way we address that is with our CSI program. And with the CSI program, we have partnerships with various agencies in our Southeast Texas region. One of the agencies that we have a partnership with is called the Spindletop Center. Spindletop Center is our local mental health center in the Southeast Texas region. And what Spindletop can do is they can address mental health needs that individuals may have. Now, in order to participate in the program, you do not have to be incompetent or insane. You could just merely suffer from depression or anxiety or any other host of mental illnesses, and they have the expertise. They have the doctors, the counselors, mental health deputies, and a various number of other individuals that work at their facility that can address mental health needs. Now, Spindletop, what they can do, first thing they'll do a private interview. The interview could be in the privacy of our jury room. It could be at their facility, it can be by telephone, or it can be by text, whichever is convenient for you. They also will do what is called an assessment. An assessment is to determine what your mental health issue is. And then they can develop a treatment plan to address your mental health issue. If you have issues with drugs or alcohol, well, Spindletop has another program. That program is called ATAR, and it's an acronym that stands for, it's ATAR, and it stands for Addiction, Treatment, and Recovery. We also have a partnership with our local drug and alcohol council that has a program, a drug and alcohol recovery program that is called OSAR. It's an acronym, OSAR, that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery program, and what they will do an interview, they call it a screening, and then they will do an assessment to determine what your drug and alcohol issues may be, and then they develop a treatment plan for either outpatient or inpatient treatment. If you are unemployed, or if you're looking for a better job, then we have a partnership with the Golden Triangle Empowerment Center that also has a partnership with Lamar University. And Lamar University has a program that is called CICE. That is an acronym that stands for Center, Innovation, Commercialization, and Entrepreneurship. It's a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. And once you're trained in every one of those areas, they will help you to get a job in the area that you trained in. Okay? And so if you have not graduated from high school, or let's say you do not have a GED, well, they have a GED program where you can get your graduate equivalency diploma. Now, all of these programs that I just mentioned to you are free. It does not cost you anything but time. And we like to say in this court, we do not just give time, we take our time. And that simply means that we do not arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to County Court Law number 2 of Jefferson County, Texas, we do not just have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. So if you're interested in any one of these programs that I just mentioned to you, just let us know. And then we will be able to direct you to the people that you need to talk to so that you can get on the road to living your best life. So now, the paperwork that you have, we're gonna give you time to finish filling it out. And then once you finish filling it out, we're going to pick up that paperwork from you. And we're gonna put you into one of 3 categories. One, you wanna hire an attorney. And if you're in that category, your case will be reset today to give you time to hire an attorney. The second category is if you like to apply for a court-appointed attorney. And if you're in that category, if you qualify for a court-appointed attorney, your attorney will be appointed today before you leave. And the third category is if you would like to waive your right to an attorney and represent yourself, then you'll have an opportunity to talk to the prosecutors here that's in court. And if you're able to work out a plea bargaining agreement, your case will be taken care of today. Now, we're going to pick that paperwork up from you, put you into one of 3 categories. If you need help with your paperwork, just let us know, because we have our court personnel who's here who will be happy to assist you with filling out the paperwork. Now, it's gonna take us a little time to finish filling out that paperwork. Before I go any further, that first document, at the top, it says the state of Texas versus, and there's a line. Please print your name on that line. Because if your handwriting is like mine, sometimes I can't even read. So just print it so we'll know who the person is. And then we'll pick that paperwork up from you. Again, if you need to use the restroom, there are 2 restrooms right outside in the hallway. We have the men's restroom in front of County Court Law number 3. And on the opposite side of the hall, we have the women's restroom in front of the 172nd District Court, which is on the opposite side of the hall from County Court Law number 3. Okay? So, do we have any questions? Yes,
Where was this actually fitted in county?
Jefferson. We in Jefferson County. Any other questions?
So what if I made, some other time in another county? Does that
If you
count?
did what?
If I made some time in another county?
If we look it up and verify it, you get credit for that. You
Well,
coming on this case?
no, yeah, this case,
Yeah, you
the case is here in Mohawk.
Yeah, I know, but sometimes that happens when somebody get arrested in another county for something, and then they get credit for that as well. Right, all that time, counts.
Okay.
Yeah, only thing we have to do is look in your file and see what county you were in, and sometimes they'll see when you were, then when they notified Jefferson County that you were there, and then it's also notified when you was released, or sometimes Jefferson County go and pick up the person from that county and bring them over here. Or sometimes they find out over there.
Another difference, does it make another difference if that county that picked me up, drop me off? Because I know Jefferson has to come pick me up because they're, okay.
No, it doesn't make a difference. One thing I was just saying that there's a way for us to verify how many days you spent. A lot of times we see when you were in that county, when you bonded out, or when you're in that county, then you came to Jefferson County from that county. And so they count the days. Yeah, it can be done.
All right.
Okay, any other questions? Yes,
I applied for the point for that.
Okay.
Later on,
you can change mine.
one.
Yeah. I mean, if you apply for a court appointed, then what's gonna happen, if you qualify, your attorney's gonna be appointed today. Okay. And so later on, you decide, hey, you think you can hire an attorney or you don't like, you can do that. I think that's what you're getting at.
Yes.
Okay, anybody else? Okay, so now we're gonna be in recess. Make sure that you conduct yourself accordingly. And so when our court personnel comes in, they're gonna line you up right here at this table. She gonna ask you if anybody's finished, they're gonna line you up right here, and then they're gonna, look at your paperwork, examine your paperwork, make sure everything's filled out, and you have a seat, and then at some point, we're gonna call you back up. Okay? Any other questions? Yes.
I pick up my daughter from school, but I'm hiring an attorney. I just got a call from the daycare.
Okay, yeah, no, let me get, them to come in here, so we can, you can start writing up over there. Yeah. Jefferson County Code Law number 2 is back in session. The court is in session in cause number 25 CCCR 2694, cases style of state of Texas versus Marcus Anthony Parr. Parr, would you please come forward? Stand in front of the bench. Mr. Parr, your full name is Marcus Anthony Parr? Parr, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Mr. Parr, you may put your hand down. How are you doing, Mr. Parr?
No.
That's good. Now, Mr. Parr, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, Judge.
And are these your initials on the line that state you'd like to have your case reset to hire your own attorney?
Yes, Judge.
Now, before you sign and initial this document, hold on, let me see, could you reach me my docket sheet? Thank you.
You're welcome, Your Honor.
Okay, before you sign this document, did you read the document?
Yes, Judge.
Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Mr. Parr, I read your answers. Your case will be reset. Did you give me his reset? Yeah, the coordinator is gonna give you a reset. Once you get your reset, you're free to go and you have a blessed day. All right. Ms. Mosby, the lady just came in. Jefferson County Court, Law number 2 is back in session. The court is in session with the arraignment docket. First case is cause number 25 CCCR 2964, case of style of the state of Texas versus, is that Julio Lara? Mr. Lara, would you please come forward? Mr. Lara, your full name is Julio Lara?
Yes, sir.
Mr. Lara, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, Mr. Lara. We have Miss Farrah Nixon from the district attorney's office. Ms. Nixon, how are you doing?
I'm fine, Your Honor.
That's good. Now, Mr. Lara, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Are these your initials on the line that state you'd like to have your case reset to hire your own attorney?
Yes,
Before you sign this document, did you read the document?
yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in this document true and correct to the best of your knowledge? Mr. Lara, I read your answers, and based on your answers, your case will be reset. Give you opportunity to hire an attorney. You get your reset from our court coordinator. Once you get your reset, you're free to go, and you have a blessed day.
Thank you.
You're welcome. Miss, I'm gonna need a copy of it. Daniel Green,
That door is locked.
Right here.
you come up here. Okay. Mr. Green, your full name is Daniel Paul Green. Mr. Green, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Green, you may put your hand down. How are you doing, Mr. Green? That's good, Mr. Green. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled defendant?
Yes.
Are these your initials on the line that state you'd like to have your case reset to hire your own attorney? Now, before you sign and initial this document, did you read the document? Did you understand what you read? Is everything in this document true and correct to the best of your knowledge? And Mr. Green, I read your answers. Based on your answers, your case will be reset to give you an opportunity to hire your own attorney. Our court coordinator will give you your reset. Once you get your reset, you're free to go, and you have a blessed day. Please stand in front of the court coordinator. London Moles. Ms. Moles, your full name is London Marie Moles?
Yes, sir.
Ms. Moles, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Moles, you may put your hand down. How are you doing, Ms. Moles?
Good.
That's good. Ms. Moles, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's
Yes,
got a
sir.
defendant? Or are these your initials on the line that state you like to have that you would like to apply for a court-appointed
Yes,
attorney? Now, Ms. Moles, I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this set document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Ms. Moles, before you sign and initial these documents, did you read the documents? Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge? Ms. Moles, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Marcus Wilkerson. Attorney Wilkerson will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day.
Thank you, sir.
Okay, please stand in front of the court coordinator. Umberto Maldonado. Okay, Mr. Maldonado, your full name is Umberto Maldonado?
Yes, sir.
Mr. Maldonado, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Maldonado, you may put your hand down. How are you doing, Mr. Maldonado?
Good, sir.
You doing good?
I have one question. Is there a way I can transfer this to my county or no?
Oh, I mean, if you transfer,
The case to my county, because I,
only time your case is transferred to your county is after your case is disposed of.
oh, I just drove 7 hours from my county, 'cause I just.
No, it can't get transferred now.
Oh, all right.
Yeah, yeah, it has, if the case got disposed of and let's say you receive probation or something, if you receive probation, they could transfer the probation to that county. But
Okay.
until, if that happens, then we can do that. If it doesn't happen, it cannot be done. But right now, your case is not even is not disposed of. So you have to come back to this court.
All right.
Okay? Now, Mr. Maldonado, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you would like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is just your signature?
Yes, sir.
Now, Mr. Maldonado, before you sign and initial these documents, did you read the documents?
Mm-hmm.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
All right, yes.
Okay, Mr. Maldonado, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you is Attorney Tom Burbank. Okay?
All right.
So, Mr. Burbank will be given information to contact you. Now, let me, before I go any further, now, Mr. Maldonado, do you have any problems speaking English?
No.
You don't? Okay. Okay, so Mr. Maldonado, Attorney Burbank will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day.
You too.
And you're not looking to file it in this.
Joachim Pugh,
Can you read your bag right there on the table?
okay, Mr. Pugh, your full name is Joachim Albert Pugh?
Joaquin Albuquerque, yes, sir.
Joachim Albert Pugh?
Yes, sir.
Mr. Pugh, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Pugh, you may put your hand down. How are you doing, Mr. Pugh?
Thank you.
You making it? Well, that's a good thing. You're still here.
Yes, sir.
Now, Mr. Pugh, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
Also have another document that's titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And is this your signature on page 2 above the line that is titled Defendant Signature?
Yes, sir.
Now, Mr. Pugh, before you sign and initial these documents, did you read the documents?
Yes, sir.
You understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Pugh, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Christy Carlton. Attorney Carlton will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Once you get that information, you're free to go, and you have a blessed day. Please stand in front of the court coordinator. Tremont Deshaun Lewis. Okay, Mr. Lewis, your full name is Tremont Deshaun Lewis.
Yes, sir.
Lewis, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you?
Yes, sir.
Mr. Lewis, you may put your hand down. How are you doing, Mr. Lewis?
Pretty good.
I'm doing fine, thanks for asking. Mr. Lewis, the state is represented in this case by Attorney Samuel Masradian, And Attorney Masrati, how are you doing?
Doing well, Judge, thank you.
That's good. Now, Mr. Lewis, I have before me two documents. The first document is titled Jefferson County. It's titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature online? It's titled Defendant.
Yes, sir.
Are these your initials online that state you'd like to apply for court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigent. Do you recognize this document?
Yes, sir.
And on page 2 of the same document, there's a set of initials, there's a signature above the line that's titled Defendant Signature. Is this your signature? Okay, Mr. Lewis, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Lewis, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Giles Cole. Attorney Cole will be given information to contact you, and you will give information to contact him. Our court coordinator will give you that information. Once you get that information from the court administrator, you'll be free to go and you have a blessed day.
Thank you.
Thank you. Stand in front of court administrator. Jody Alexander Connor. Mr. Connor. Let's see, hold on a minute.
Excuse the conditions. That's what I
Okay, Mr. Connor. I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you like to apply for a court-appointed attorney?
Yes, sir.
Now, Mr. Connor, I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page, let's see. On page 2 of this document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Mr. Connor, before you signed and initialed these documents that I'm showing you, did you read the documents?
Yes, sir.
And did you understand what you read? And is everything in this document, in these documents, true and correct
Yes, sir.
to the best of your knowledge?
Yes, sir.
Mr. Connor, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Jennifer DeLage. Attorney DeLage will be given information to contact you. You will be given information to contact her. Our court coordinator or court administrator will give you that information. Now, before she gives you that information, I need to give you some bond conditions. The bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that document?
Sir.
Okay, I'm going to go over these bond conditions, which it says, following return of criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release for any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state or the United States. Do you understand that condition?
Sir.
And condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that?
Yes, sir.
Also, let's see now, condition number 4 does not apply in your case. Condition number 5 does apply on the next page, and it states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
And condition number 7 states the defendant shall wear a global positioning monitoring system device at the defendant's expense, with written verification being submitted to the court within 3 days after the day. Do you understand that condition? You understand that? Now, if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested, placed in the Jefferson County Jail. Do you understand that?
Yes, sir.
Okay. And the court administrator is going to give you a list of locations where you can get the GPS. Okay? All right. All right. You have a blessed day. I think I didn't get that other guy's paperwork. Um, where's this here? This is, oh, on Zoom.
Oh, yeah, Benjamin.
We called yesterday.
Okay.
All the traffic.
Tavares Levon Benjamin. You can take your mic off of mute. Tavares Benjamin, how are you doing?
Yes, sir.
Okay, you're kind of breaking up.
Good.
You're breaking up. Hello, can you hear me? I think you can hear me, but you're breaking up. Yeah, Mr. Benjamin,
Give me a little better.
that's a little bit better. Oh, you just put your mic on mute. Take your mic off of mute. Did you give him a code date? Mr. Benjamin. Mr. Benjamin?
Yes, sir. I'm here.
Okay, now, Mr. Benjamin, your case is going to be reset. You've already set through part of the arraignment. So we need to reset your case so that you can come in court in person to fill out the paperwork.
Yes, sir.
Okay, now, what was the reason why you wasn't able to make it here today?
My mom recently got to an accident, so that was my ride. Besides her, that was the only reason. I mean, that was the only way I was gonna make it.
Okay, now,
But I
do
stay.
you live in Beaumont?
No, I stay in Port Arthur.
You stay in Port Arthur?
Yes, sir.
Give him 2 weeks.
August 25th.
Okay, your case is gonna be reset to August 25th of 2026. And on that day, you need to be in court in person,
Yes, sir. That's fine.
okay?
Yes, sir. I understand.
Okay, so you're free to go and you have a blessed day,
You too.
okay? Okay. Jefferson County Call number 2 is in session. The court is in session and calls number 25 CCCR 2708, case of style of state of Texas versus Jacoby Deontay Hope. Mr. Hope, is that your full name?
Yes, sir.
Mr. Hope, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Hope, would you please put your hand down? How are you doing, Mr. Hope?
I'm doing fine.
That's good, Mr. Hope. I have before me a document. Well, first of all, before we get started, Mr. Hope, you have a right to have a court reporter to dictate or to type down everything that is being said in this case. You also have a right to waive your right to have a court reporter, which means you have a right to give up your right to have a court reporter. Do you understand that?
Yes, sir.
Now, do you waive your right to have a court reporter?
No, sir.
So you want a court reporter? Okay, let's call, yeah, we're gonna call, our court reporter, just, it'll be in a few minutes. He's calling, Sebastian.
Thank you. He's coming.
I like my paper.
So, Mr. Hope, so you're waiving your right to have a court reporter?
Yes, sir.
Okay, now, Mr. Hope, I have before me on my document, on my computer, a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Jacoby Deontay Hope, on or about July 30th, 2025, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of possession of marijuana that had a weight of less than 2 ounces. Mr. Hope, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Hope, how did you plead? Guilty, not guilty, no contest?
Guilty.
Now, you pleading guilty freely and voluntarily?
Yes, sir.
Okay. And, Mr. Hope, I also have before me on my computer tablet, a document. I have before me on my computer tablet, a document that is titled information, a document that is titled misdemeanor plea admonishment. This document is also listed as State's Exhibit number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's set of initials, 2 sets of initials. The first set of initials on a line next to a box that says check guilty to place your initials on this document.
Yes, sir.
And on the second set of initials are on a line next to a box that state, I do not request discovery. I waive my right to discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials in the second location?
Yes, sir.
Okay, on page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal. Is this your signature?
Yes, sir.
At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box check states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. You understand that statement?
Yes, sir.
I also have a document that is titled Discovery, that's titled Judge's Explanation of Rights to Defendants Without Attorney. And do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that states you like to waive your right to attorney and represent yourself?
Yes.
I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea and Proceeding to Trial. And is this your signature on the line that's titled Defendant?
Yes, sir.
Mr. Hope, before you signed and initialed all of the documents that I showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Hope, are you a citizen of the United States?
Yes, sir.
The state offers to this court State's Exhibit Number 1.
Okay, now, Mr. Hope, the state is offering State's Exhibit Number 1 to be used as evidence against you in this case. Now, State's Exhibit Number 1 is the first document that I showed you on this tablet. It is the same document that has your initials in these two locations, and it has your signature above on page 3. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
Okay. Now, Mr. Hope, State's Exhibit Number 1 is admitted. Mr. Hope, is there any evidence that you are currently mentally incompetent to stand trial? No? Okay, Mr. Hope, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what's the agreement?
It would be 2 days within the county jail, time served, time actually served, credit for the time served, and those costs should be taxed and retired.
What's the court cost?
If there's enough.
Okay, 337. Okay. Okay, now, Mr. Hope, the state is offering that you serve 2 days in the Jefferson County Jail. However, you would not be required to serve any more time in the Jefferson County Jail because you'll be given 2 days credit.
Yes,
You'll
sir.
be given credit for time served. Now, the court cost in this case is $337. But you have 2 days credit that will go toward that, and 2 days, each day is $100. So it's a total of $200 credit that's going toward the $337, which leaves a balance of $137. Are you able to pay that?
I could try to get it today, or I can do a payment plan.
Okay, let me do this here. Now, I have a document before me that is titled Affidavit of Indigence. Do you recognize this document?
Yes, sir.
Is everything on this document true and correct today?
Yes, sir.
Okay. Now, Mr. Hope, the court is going to find that you're indigent. And based on the finding of indigency, the balance in this case of $137 will be waived, which means you will not have to pay it. And that's pursuant to Article 42.15 of the Texas Code of Criminal Procedure, because the court has found you to be indigent. Do you understand that?
Yes, sir.
Now, do you understand the state's offer?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Mr. Hope, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Hope, you're gonna stand next to the bailiff, follow her directions. Once you're finished following her directions, you'll be free to go, and you have a blessed day.
Thank y'all.
You're welcome.
Thank you.
Good luck to you and your family as a UPS man, are you?
Yes, sir.
All right. And this will conclude the calling of the court's Raymond docket on today's date of August 11, 2026, in County Court Law Number 2, Judge Terrence L. Holmes presiding. Everyone, please have a blessed day.